Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great docket for you today. Let's give you a preview. First, Larry Woodcock wants to bury his grandson. Why can't he? Next, the Debbie Collier case. More questions than answers at this time. Most would probably agree Eliza Fletcher may be here today if the Memphis Police Department moved more quickly. Well, one woman is suing the city for their alleged negligence. A deceased woman, missing boyfriend found in another state. Coincidence? A WTF moment captured on video. A Florida police officer is in big trouble. Wait till you hear for what. I know you can't make this stuff up. And then finally, our dumb criminal of the day, who is truly dumb. Let's talk about it. All right, aficionados, thanks for watching. Let's get right to it. First, some housekeeping issues, though. Remember, subscribe if you have not. Hit that like button if you like the program. Hit the bell for notifications and leave me a comment below regarding the cases that we are going to discuss today. And remember, you can listen to us on your favorite podcasting app. Just simply search Crime Talk. Before we get to the docket, that's right, we got to pay some bills. So let's support the people that support Crime Talk. Please go to CrimeTalkPrep.com. You'll be happy you did. Why, you ask? Well, whoever would have thought that there'd be shortages of any type in the United States? Well, we've all seen it, and I think there are more to come. The reality of it is, if there's an emergency, a disaster of any kind, guess what? You are on your own. You need to be able to take care of yourself and your family. So when you go to CrimeTalkPrep.com, you can save 20% for a 3-month food supply. Now, you may think, well, Scott, I don't want 3 months. Well, you don't have to order that much. You can order less. You can order more. You can buy them out if you want to. But the reality of it is you need to be prepared. Just like when you're growing up, the family had some canned goods down there in the basement or in the pantry for you never knew what. Well, now, but you can do it through CrimeTalkPrep.com. So do that, get 20% off. All right, so let's get to the docket for Thursday, September 22nd, 2022. All right, and a certain theme is developed, and I think the theme today would be that it's kind of scary to be a woman in the world today. All right, first on the docket, Larry Woodcock would like to bury his grandson, JJ. Why can't he? Now, he had said in an interview that JJ is in a vault right down here in town right after the hearing the other day in the Lori Vallow matter regarding the hearing to not have cameras. He stated he's in a freezer. And he also said, come on, Judge, let us have him so that we can bury him. Mr. Woodcock wants to do what's right. Now, full disclosure, I have met Mr. Woodcock and his lovely wife in person. I like them both. I like Larry. When we met at CrimeCon, we were able to talk. He is a very nice man. He's a very successful businessman. We talked aviation. Listen, this is not a man who's looking for fame. He doesn't need the money. He is seeking justice. And Larry didn't become so successful in business by having people tell him no and by just stopping or giving up when somebody said no. He will not rest until he gets justice for JJ and Tylee. And also, out of full disclosure, he's even called into our Patreon show in the past because he wanted to get the analysis of the case straightforward. So he watches here on Crime Talk. Talk about a great privilege, honor, I guess, so to speak, when a victim's family members comes to you to get the straight shooting advice, so to speak, as to what is taking place in the case, because apparently they're not getting the information. And as a quick recap for those who don't know, Mr. Woodcock's 7-year-old grandson, Joshua, who we all know as JJ Vallow, and his sister, 16-year-old Tylee Ryan, were discovered buried on Chad Daybell's property back in June of 2020. Now, Chad Daybell is married to the children's mother, Lori Vallow. After JJ and Tylee's remains were found, they were taken to the Ada County Coroner's Office for an autopsy. Now, Tylee's body was allegedly dismembered and burned, while JJ's body was wrapped in tight black plastic and secured with gray duct tape. Now, authorities have not released a cause of death for either child. Now, Mr. Woodcock has said he doesn't care about Lori. I don't care about Chad. Is what they did right? No, it was wrong. It was horrible. I don't even know how you comprehend doing something like that at this point. I just don't care. Let us have the kids. Let us bury them. Let us do the right thing. And I'm begging the court, Mr. Woodcock said. Now, I can understand the frustration of the Woodcocks who have had to endure everything that's taken place. My heart goes out to them. And the children should be buried. Now, remember, the defense has a right to conduct their own independent autopsy if they choose to do so. This would include, trying to collect DNA samples. This is particularly important if there's an issue regarding the cause of death. Maybe there's something that they may be able to determine as it relates to a time of death. We don't know because everything has been hush, hush. Now, by way of an example, I had a multiple deceased child case, and in that particular case, no one could determine the cause of death. Multiple autopsies were conducted by the government. They sent the remains out of state. We obtained a doctor to conduct an independent autopsy, and so literally these remains were being FedExed around the country. Now, I hope that hasn't happened in this particular case, but that's an example of what potentially could take place. We would have let the remains be released after our autopsy had taken place. And that's the kind of question. Here we are 3 years. Obviously, the defense has a right to inspect the evidence, to have their own independent testing done if they choose to do so. But I would also say they have a right to do it in a reasonable time. The prosecution can also put deadlines and say, hey, judge, we would like to release this evidence. We want a court order or something from the defense saying, we're done. We've completed all of our testing to this point. So, like I said, here in the Daybell matter, there's been so much secrecy regarding this case. We don't know what exactly was the cause of death, if it's been determined, if there's an issue regarding it. Maybe if we were able to see some of the court filings, we'd be able to glean something from those pleadings. Like I said, in the case that we had to get permission from the court, which was in the public record. And anybody could have gone and looked it up and saying, hey, we're having the remains, an independent autopsy conducted. But like I said, we don't get access to hardly anything in this case unless the court deems it completely, basically non-prejudicial in any way. Well, it's litigation. It's always prejudicial to one side or the other. And ultimately, the prosecutors and the defense here could agree that both sides are done with the remains and release the remains to the family. Clearly, that's not taken place. It could be the prosecutors who are not willing to release the bodies. It could be the defense. We just do not know. Now, the Woodcocks will have to wait a little longer, and I am sorry they have to go through all this. The case against Lori Vallow and Chad Daybell, remember, may never have hit the criminal justice system if the Woodcocks didn't care about their grandson and didn't ask for a welfare check. If one of those situations where nobody had seen the child and nobody cares, guess what? They would have got away with it. We owe our respect to the Woodcocks for pressing on. Next, the Debbie Collier case. More questions and answers. Well, we brought you the story earlier in the week, so quick recap. Ms. Collier went missing on September 10th after sending her daughter $2,385 over the Venmo app and a cryptic message reading, "They are not going to let me go. Love you. There is a key to the house in the blue flower pot by the door." Now, her daughter and husband reported her missing that afternoon. Police were able to use the Sirius XM radio in her rented Chrysler Pacifica to track its whereabouts to Georgia Route 15 in Clarksville, an hour's drive away from where Collier, a real estate office manager, lived in Athens, Georgia. A canine unit found her remains under some grisly circumstances down an embankment in a wooded area about a quarter mile from the vehicle. She was nude and partially burned. Now, charring on her abdomen and her right hand, where she was also apparently clutching a tree. Those signs may indicate that the attacker may be familiar with the area, attempted to dump the body and hide the body. Nearby, police found a red tote bag, a partially burned blue tarp, and the remains of a fire. Well, On Wednesday, the Habersham County, Georgia Sheriff's Office revealed that investigators have found no evidence of either suicide or kidnapping. Detectives have served several search warrants and sought to identify persons of interest. Now, could the charring indicate they were trying to destroy, obviously, evidence, DNA? Maybe they were failed in their burning attempt somehow, and there will be DNA to be discovered. Was there something sexual about the crime? Certainly being naked would make one think so, but we don't know officially yet. It's unclear where the attack on Collier took place. If it began at her home, there could have been a grudge or a financial motive. Who knows? Could it be a possible carjacking or some other sort of random attack? Now, there was some sort of commotion at the house, according to a neighbor that has stated that Saturday night before Debbie disappeared, noting she frequently heard shouting from the Collier home atop a small wooded hill in Athens, Georgia. Now, the neighbor added, somebody comes up to visit on the weekends and in the evenings, and there's loud screaming and fighting, said this neighbor. And they also said that the visitor was a younger woman. Now, the victim's husband, Steve Collier, told investigators he last saw his wife at 9 p.m. on Saturday, and her car was still in the driveway when he left for work the following morning. And he told the investigators he slept separately from his wife because he snored and that he didn't see her before she went missing. When he was approached by reporters, he declined to speak. I wouldn't read anything into that. There's been no indication that Mr. Collier is the suspect or a person of interest in any way. We just don't know, but this is going to be an interesting case because something just doesn't seem right. All right, next, Eliza Fletcher. Okay, Eliza Fletcher would probably be alive today if the police had acted on a previous sex assault case. Well, guess what? That woman is now suing the city. So a Tennessee woman says that in 2021, she was sexually assaulted by the man who would later be charged with kidnapping and killing Eliza Fletcher, and she is now suing the city of Memphis over what she describes as its negligent failure to investigate the attack. In a lawsuit filed Tuesday, Alicia Franklin says that Cleotha Abston raped her back in 2021, less than 1 year before the alleged kidnapped Fletcher in the early morning hours of September 2 of 2022. Now, Ms. Fletcher was out on a morning run near the University of Memphis when Abston allegedly ran up to her and forced her into an SUV. Her body was found days later. Now, Franklin, who has discussed the case in several interviews, said that in 2021 she had communicated with a man named Cleo for about a month through text messages and a dating app. Franklin says they met in person on September 21st at the Ridgeway apartment complex, where Cleo said he was a maintenance man for what was supposed to be their first date. Now, according to the complaint, Cleo was actually Abston, and he also allegedly went by the name of Cleotha Henderson. They allegedly had plans to go out for dinner, but Cleo drew a gun on her instead. According to Ms. Franklin's lawsuit, he allegedly forced her into a vacant apartment where he blindfolded her with a t-shirt and threatened to kill her. He walked her through the apartment, according to the complaint, and outside the back of the apartments to his car, a white Dodge Charger, where he forced her into the back seat and raped her, according to the complaint. Attempting to talk him out of it, Franklin said that she was pregnant. Cleo was unmoved by her plea and responded with words, "All you bitches say that," or substantially similar words, indicated that he had likely raped other women, according to the complaint. Now, after the attack, Abston allegedly forced Franklin back into the apartment at gunpoint and ordered her not to leave until she heard his car engine revving. He was charged with obviously sexually assaulting Franklin almost a year after allegedly attacking her, and authorities said a DNA match in the 2021 rape case finally returned a match on September 5th of 2022, the same day Fletcher's body was found in South Memphis. Franklin says that police did far too little to investigate her 2021 case. In her complaint, she said she took a rape kit after the incident. Police took her back to the scene of the crime, but they took no physical evidence directly from the scene itself. She also says that she gave police information such as the name Abston allegedly provided, Cleo, his phone number, a description of his vehicle, and social media information, including the dating app. She also told them about the pregnancy comment. Authorities already had access to Abstin's DNA from his 2001 guilty plea for kidnapping and robbing an attorney within hours or days. Police gave Franklin a visual lineup that included Abstin. The complaint asserted that police already had the evidence they needed to arrest him for the sexual assault and that they should have been well aware of his criminal history dating back to age 11, which included an alleged sexual assault. Now, Miss Franklin was not able to identify her attacker based upon the photographs that she was shown at the time in the lineup, according to the lawsuit. Miss Franklin overheard the police say something to the effect of, maybe we should show her a more recent picture. This photo was probably when he was 12 years old. But police either failed to get the picture or they failed to tell her, according to the lawsuit. And according to the complaint, authorities had access to more current photographs from Abstin's time in the Tennessee prison system, and he had been released from prison on the kidnapping and aggravated robbery charge back in November of 2020. Now, officers also allegedly failed to ask the Tennessee Bureau of Investigation to do a rush review of the suspect's DNA in Franklin's case. And by comparison, Franklin's lawsuit said officers in the Fletcher case submitted a sandal or a DNA information from a sandal to the Tennessee Bureau of Investigation requesting an expedited analysis. And in just hours or a few days, the TBI, the Tennessee Bureau of Investigation, replied that the DNA on the sandal matched Abstin. Essentially, Franklin's complaint alleges police had all the evidence that they needed to stop Abstin from allegedly striking again. He was also already on their radar. They knew he had a lengthy record, and they should have known he was a continuing danger to Franklin and the community. They state in this complaint, Cleo Abstin should and could have been arrested and indicted for the aggravated rape of Alicia Franklin many months earlier, most likely in the year 2021, based upon all the information set forth in the preceding complaint paragraphs. And the abduction and murder of Eliza Fletcher would not have occurred, according to the complaint. That seems pretty reasonable. For now, local law enforcement obviously is not talking at all, but they allege, obviously, that Cleo Abstin should and could have been arrested and indicted months earlier. So you have to wonder, gee, when they have a sexual assault kit, why did they not do a rush DNA and put it through the CODIS system, which stands for the Combined DNA Index System, which basically anyone, if you have a criminal history, is in there. Now, the complaint alleges, because remember, in any sort of civil complaint, you have to show that there is a duty by somebody involved, that they breached that duty, and but for the failure of that duty and the causation, that there are in fact damages. Here, the complaint alleges that the city of Memphis was required by the law of the state of Tennessee to perform an audit of its sexual assault kits and an audit in the year 2014 to determine that the city of Memphis had more than 12,000, get that, 12,000 sexual assault kits in its possession, including more than 6,000 sexual assault kits that had not been submitted for testing. Now, since the Tennessee Bureau of Investigation rarely knows the facts of the case relating to each sexual assault kit submitted to the TBI, then TBI relies upon the submitted agencies, including the Memphis Police Department and the city of Memphis, to identify cases that would benefit from investigation on a rush basis. Tennessee law, according to the complaint, alleges that there is a duty imposed upon police officers to investigate crimes reported to them, and Tennessee law imposes or should be construed to impose a heightened duty to investigate violent felonies like rape committed against victims with a deadly weapon thoroughly by utilizing available evidence on a timely and expedited basis. And the complaint alleges that they breached that duty, in this case directly and approximately caused harm, which would not have otherwise occurred. Now, because the sexual assault kit from Alicia Franklin's sexual assault was not sent to TBI with a rush request or a request to it be processed on the expedited basis, no CODIS hit or match was obtained for Cleo Abstin until months after the alleged rape. And there are numerous private forensic laboratories that are certified to do DNA testing for municipalities for a fee, and these laboratories were available back in September of 2021 to process the plaintiff's sexual assault kit. And knowing that it would likely take several months, if not years, to get the results back from the Tennessee Bureau of Investigation without a request for an expedited processing. Yes, ladies and gentlemen. Wow. And I understand where the victim is coming from in this case. Miss Franklin, she wants justice. Nothing was done. The police, they sent it off where literally, I'm telling you, here where I practice law, it takes a trial setting for DNA evidence to get tested unless they are doing a match early on and there is a request for it. DNA testing is expensive. It's not something you just go and you do. It takes, on a rush basis, still several days to do the extraction, the testing, the analysis of the interpretation of all the DNA numbers that come out. So I get their frustration. I get Miss Franklin's frustration in this particular case. But I think, unfortunately, this case was probably going to get kicked out of court. Why, you say, Scott? Let me tell you why. It's called sovereign immunity, right? You can't sue the king unless the king gives you permission to do so. Now, it's very vague in the complaint when I read it. It doesn't necessarily identify how they intend to get around sovereign immunity in this particular case. But it is clearly a statement saying, hey, police agencies, not only in Tennessee, but in other jurisdictions, you better get your act together because one of these cases could stick. And what I mean by stick is it could go forward and suddenly the city winds up paying lots and lots of money and there could be civil liability for the police officers. Now, do the police officers, could they have rushed it? Probably, but they're probably given marching orders that saying, hey, this is an expensive process to do. Who knows what the cops were thinking, but they didn't rush it. And it wasn't until Miss Fletcher, apparently, the heiress of a billion-dollar fortune, that they were actually able to expedite something. I mean, I don't want to necessarily say it depends on who you are, but sometimes it depends on who you are. What do they say? Everybody's equal, but some are more equal than others. Just saying. Anyway, obviously the Fletcher case is tragic. I agree she'd probably be here if the police had done it. They dropped the ball, but I'm not sure the case is going to go forward. Now, we could have a huge discussion on another day about the whole social contract theory of society and what the role of the government should be and what we give up when we say, hey, protect us. But we're not going there today, all right? Next on the docket, dead woman, missing boyfriend, found in a different state. Coincidence? I think not. A South Carolina woman reported missing with her boyfriend last week was found dead from a single gunshot wound at the couple's home in Lawrence County, which is in South Carolina. Now, Terry Shermack and Todd Cagle were reported missing on Saturday by someone who said they'd last seen Shermack in April, but had communications with her earlier this month. Well, the United States Marshals arrested Mr. Cagle Tuesday afternoon just outside his hotel here in Denver, Colorado. The couple had not been seen since September 9th, and Cagle was arrested on charges for an arrest warrant for murder and possession of a weapon by a previous felon, and is in the downtown detention center waiting for some extradition paperwork to be sent over so that he can get back to South Carolina. Now, certainly we'll give him the presumption of innocence, but I think flight, ladies and gentlemen, you get the flight instruction, right? Everybody's looking. You're the only one driving away. You're the only one driving away when everybody else is looking. It's called consciousness of guilt. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Next on the docket, WTF. F. Please meet Edmund Burke. He went into the trading post in Burnt Store Marina, a family-owned restaurant and store in Punta Gorda, with the son of an elderly man for whom he acted as a caretaker. Clark and the victim had entered the store together and were ordering food. The pair could be seen choosing drinks and placing them on the counter. Suddenly, Mr. Clark grabs a pair of scissors from a nearby cup before lunging at the victim. Now, this bloody attack was all caught on surveillance video, while at least 2 other people in the store witnessed the brutal attack. And I'm sure they were probably videotaping it on their phones. That's just the way the world is these days. Anyway, the victim was stabbed more than 40 times in the head, neck, and torso area. Deputies with the Lee County Sheriff's Office say that Clark could be seen hacking away at the man trying to behead him. It was several minutes before the police arrived on scene to tackle Mr. Clark. All the while, the gruesome attack apparently continued. Nobody intervened. Probably too videotaping. The victim was rushed to the hospital suffering from severe wounds to his head, neck, and torso. Mr. Clark had served as a caretaker for the victim's father for about a decade. The pair had met up before the incident after the victim picked up Clark from the hospital after suffering from abdominal pain. Now, after leaving the hospital, Clark told the victim he was hungry, so the pair stopped at the Trader Post store and were ordering when the unprovoked attack suddenly began. Witnesses reported hearing Clark suddenly experiencing what they refer to as hallucinations as he ranted about being targeted by an unknown enemy. It was then that this violent and vicious attack began. Obviously, Mr. Clark was arrested at the scene, has been charged with attempted murder. Yeah, crazy world, ladies and gentlemen. Be safe out there. And in the you can't make this stuff up category, listen to this story. A 23-year-old police officer in Florida was fired from his job, wait for it, for allegedly engaging in illicit sexual relationships with a 13-year-old girl while he was on duty. Please meet former officer Sheridan Edwin Archer of the Palm Bay Police Department. He was charged with 2 counts of lewd and lascivious battery of a victim under the age of 16. Obviously, these are felony charges. Now, Mr. Archer is accused of having sexual relations with a 13-year-old female and was employed with the Palm Bay Police Department at the time of the alleged crimes. The investigation into Archer began on Sunday, September 18th, when personnel at the Palm Bay PD reached out to the Florida Department of Law Enforcement. The department notified the agency about the allegations against Archer and requested that the agency investigate the veracity of the claims. When what was discovered, it was determined by the Florida Department of Law Enforcement that they would run the investigation. A probable cause affidavit provides additional details on the allegations against Mr. Archer, and according to that affidavit, investigators discovered that Mr. Archer met the young girl while using a social media app called Meet Me between August 1st and August 20th. The app, which was previously known as My Yearbook, is designed for making friends, playing games, and even falling in love, according to their website. Well, Mr. Archer went to the girl's home on 2 separate occasions and allegedly committed lewd and lascivious battery. Now, during both of the alleged encounters, Mr. Archer was, like I said, on duty. The victim was reportedly able to identify Mr. Archer by his tattoos and maybe his uniform. Well, based on the investigation's results, agents with the FDLE determined that they had sufficient probable cause for an arrest and took Mr. Archer into custody. He's been booked into the Brevard County Jail and is currently on a $500,000 bond. Needless to say, the police department only issued one statement saying that he has been terminated, effective immediately. And apparently he'd only been with him 9 months, so don't blame us. We hardly knew the guy. But of course, there's lots of screening that goes into finding the police officers these days. But really, 23-year-old cop and a 16-year-old. Wow. 13-year-old. Wow. What can you say? All right, dumb criminal of the day. Now, take a look at this picture. I'm not trying to disparage the appearance of our dumb criminal of the day, but look at that gaze in his eyes. It has practically dumb written all over his forehead. Now, I know it's not a glamour shot. Try not to look dumb when you get your picture taken at the police department. All right. Well, police in Bradenton, Florida arrested a man accused of stealing a pickup truck from a hospital. Then he spray painted the vehicle in a failed attempt to escape the crime. Police said the 1998 Chevrolet S10 truck had been stolen from the Manatee Memorial Hospital on August 24th. When police located the vehicle on Friday, 3 weeks after it had been taken, they said that the 35-year-old driver, Joshua Hart, had given it a makeover. Officers arrested Hart, who used black spray paint on the truck. He removed its Salute Veterans bumper sticker and the Florida license plates and took off a Michigan State sticker on the rear window, hoping that no one would recognize it and that they would never know. They'll never know. It didn't work. Obviously, the truck's been returned to the owner, but it's not exactly in the best condition. Look at that paint job. Isn't that sweet? Well, Mr. Hart faces multiple charges, including grand theft auto. He is being held in the Manatee County Jail. A lot of stuff going on in the Manatee County Jail this week on a $6,000 bond. Now, Mr. Hart, I'm not telling you how to rob cars or anything, okay? But what you did was dumb, okay? It's not about the color of the vehicle. It's all about the VIN, okay? You got the one up in the window that the police can see all the time. They usually have one on the door, and there's usually one on the frame as well. You got to change them all, buddy. You got to change them all, Mr. Hart. Not doing that, you've done nothing. It's like its own little DNA for that car. Just saying. Maybe handled some chop cases over the years. Just saying. But painting it, not good enough. And there's been no word on how many cans of spray paint it took to paint the entire car. Let's hope he doesn't get into the auto body business either. All right. That's all we have for you today. I hope you enjoyed the show. We'll see you next time on Crime Talk.